Welcome to EUPrivacyForAll, Session 9 on the published GDPR, Article 30 on records of processing activities. The Article 28 on records of processing activities, debated in trilogue negotiations, was finally renumbered Article 30. It lays down that each controller, and where applicable, the controller's representative shall maintain a record of processing activities under its responsibility. Such a record shall contain the name and contact details of the controller, and where applicable the joint controller, controller's representative, and the data protection officer, the purposes of the processing, a description of the categories of data subjects and of the categories of personal data processed, the categories of recipients, where applicable transfers of data to third countries or international organizations, where possible the envisaged time limits for erasure, and where possible also a general description of the technical and organizational security measures. Each processor will also have the same obligation to maintain a record of all categories of processing activities carried out on behalf of the controller. It shall contain the name and contact details of the processor or processors and of each controller on behalf of which the processor is acting, the categories of processing carried out, where applicable transfers of data, and where possible a general description of technical and organizational security measures. The records shall be in writing, including in electronic form. The controller or the processor, and where applicable the controller's or the processor's representative, shall make the record available to the supervisory authority on request. The obligations referred to previously shall not apply to an enterprise or an organization employing fewer than 250 persons, unless the processing is likely to result in a risk to the rights and freedoms of data subject, the processing is not occasional, or the processing includes special categories of data. Other interesting provisions in the GDPR are laid down in Recital 82. The controller of the processor should maintain records of processing activity and is obliged to cooperate with the supervisory authorities. In Article 33 on notification of personal data breach to supervisory authority, the notification shall include a description of the nature of the personal data breach, including, where possible, the categories of approximate number of data subjects concerned, but also the number of data records concerned. In Article 49 on derogations for specific situations related to data transfers, the controller or the processor has the obligation to document the assessment as well as the suitable safeguards in records. In Article 18.2 of the Directive, it is laid down that Member States may provide for the simplification of or exemption from notification, for instance, if the controllers keep the register of their processing operations. What should accountable data controllers and processors get prepared for? First, they should get ready to document all processing activities under their responsibility. Drafting records of processing activities shall be done in writing, including in electronic form. Upon request, they have the obligation to make the records available to the DPA. And they should document suitable safeguards with regard to data transfers. But let's note a specific caveat. This records obligation shall not apply to an enterprise or an organization employing fewer than 250 persons, unless the processing carried out is likely to result in a risk for the rights and freedoms of data subjects, the processing is not occasional, or the processing includes special categories of data. So the question now is knowing about the records format and whether or not there will be some templates.